This week we're going to be introducing RIA Compliance. We're going to hit a lot of topics. Please keep in mind that in the subsequent weeks we are going to be taking a deeper dive into the various topics that come up today. So if you have questions wanting clarification, just keep in mind that custody, for example, will be discussed more in depth in another webinar, and today we're just going to kind of go over it and introduce a lot of different concepts and topics. So with that, let's go ahead and get started. So, money managers, investment consultants, and financial planners are all regulated as investment advisors under the Investment Advisors Act of 1940. I will be referring to the Act as the Advisors Act or just the Act. If you're a state registered advisor, you are going to be regulated by similar state statutes. So the Advisors Act was actually the last in a series of federal statutes that had been intended to eliminate abuses in the security industry that Congress believed contributed to the stock market crash of 1929 and the Depression of the 1930s. In order to be defined as an investment advisor, you have to receive compensation, be engaged in the business of providing advice to others, or issuing reports or analysis regarding securities. So what does that all mean? Compensation has been broadly construed. Generally, it's the receipt of any economic benefit, so that can be an advisory fee, a fee related to the total services rendered, a commission, or some sort of combination can satisfy that element. The person receiving the advice or a third party can pay the compensation. So just because the person receiving the advice isn't paying does not mean that that compensation element is not met. You also have to be engaged in the business of providing advice. This doesn't mean that this has to be the sole or primary activity of the firm, but the factors that are considered to evaluate whether or not you're engaged in the business of providing advice, regulators will look at whether you hold yourself out as an investment advisor, whether you're receiving compensation, and then the frequency and specificity of the investment advice that you provide. So generally a person is going to be providing advice about specific securities, is going to be engaged in the business unless that advice is rendered in only rare or isolated occasions. And then the third element of the test is if you provide the advice about specific securities to others. So this could be stocks, bonds, mutual funds, limited partnerships, commodity pools. The SEC has come out and said that advice about real estate, coins, precious metals, or commodities is not advice about securities. Now, the more difficult questions of when you're giving advisory advice arise when it's less specific advice that you are given, or advice that's only indirectly about securities. So a couple of things that the SEC has come out and said is being in the business of giving advice about securities would be, for example, advice about market trends, advice about the selection and retention of other advisors, advice about advantages of investing in securities versus other types of investments, or even providing a selective list of securities, even if no advice is provided as to one specific security. And then asset allocation advice is also considered to be providing advice about securities. Other questions that usually arise in terms of whether someone is an investment advisor is when the client is not a natural person like me and you, so an entity, for example. So the SEC will look to the substance of the arrangement rather than its form. So a general partner of a limited partnership that provides advice with respect to investments of a partnership is advising others, even if the general partner may have legal title to those assets. A wholly owned corporate subsidiary exclusively advising the parent or another wholly owned corporate subsidiary would not generally be considered advising others. The SEC also does not believe that the Act applies to those whose activities are limited to advising issuers, considering the structuring of their securities offerings, so investment banking. And the Act is silent as to whether clients must be U.S. persons. The SEC has taken the position that a U.S. person providing advice exclusively to non-U.S. persons could still be subject to the Act. And part of that's going to depend on where that non-U.S. person is living. Now, there are exemptions to the definition. You'll see them listed. The professional exclusion is available only to those professions listed, and only if the advice is given, the advice that is given is incidental to the practice of their profession. Same thing with a broker or dealer. Again, even if they are registered with the SEC, they're excluded from the Act if the advice they give is solely incidental to the conduct of their business and it does not receive any special compensation. Publishers are excluded from the Act, but only if a publication provides impersonal advice, so advice that's not tailored to the individual needs of a specific client, contains disinterested commentary and analysis rather than promotional material disseminated by someone touting particular securities, and it has to be of a general and regular circulation rather than being issued from time to time in response to episodic market activity. So this is why there are a lot of folks out there who may have blogs about investing, and some of the material they may be posting could in fact trigger this definition of investment advisor, and that's where we see some very interesting case studies in terms of the SEC coming in and saying that they are they're investment advisors, they're unregistered, and then facing disciplinary actions as a result. And this is also a reason why we're very careful about the kind of advertising, digital social media content you have. It's because you are triggering the definition of an investment advisor, and you're triggering the fact that you are giving advisory services. So depending on the structure of your business, you have to be careful about the content you put out there. So when do you register as a registered investment advisor? So generally you're not registering until you have about 100 million in AUM. Now you'll see here I divided by small advisors, mid-size, and then non-US. So actually in the state of New York, mid-sized advisors have to register with the SEC when they reach the 25 million in AUM threshold. Before, if you were a advisor in Wyoming, you also had to register with the SEC. Now, Wyoming now does have oversight of investment advisors in its state, so that's no longer an issue there. And then for all other advisors, the general threshold is 100 million AUM. Advisors who have a principal office and place of business outside the U.S. are not prohibited from registering with the SEC. If they're giving advice to people in the U.S., they must register unless there's an exemption available. There are exemptions which would allow you to register with the SEC, so advisors to investment companies. If they're your sole client, then you can register with the SEC. Advisors to BDCs, so with at least an AUM of 25 million, would register with the SEC pension consultants. So if you're providing services to employee benefit plan having at least $200 million in AUM, you're going to register with the SEC. Related advisors, so if you are controlled by, control, or under common control with an investment advisor who's already SEC registered, you can go ahead and register with the SEC so long as you have the same office and address. Newly formed advisors, so if you anticipate within 120 days of your registration of meeting the applicable AUM threshold, you can go ahead and register with the SEC. Similarly, if you would be expected to register in 15 or more states, you may do so. And robo-advisors providing certain advice may also register with the SEC. State law still applies. So state laws require an SEC registered advisor to comply with state anti-fraud prohibitions. And regardless of whether or not you are SEC registered, you will have to also comply with federal anti-fraud prohibitions. You're going to have to provide the state regulator with a copy of your SEC registration. This is where you're notice filing in their state, letting them know you're SEC registered and you're doing business in their state. Many states require that you pay state licensing and renewal fees. And then, of course, your investment advisor representative, that is governed at the state level. So your licensed persons are also going to be regulated by state laws. So you are still going to have to be wary of the laws of states in which you're doing business and that you're notice filed in. So there are 5 types of requirements on an advisor: fiduciary duties to clients, substantive prohibitions and requirements, contractual requirements, record-keeping requirements, and administrative oversight by the SEC or a similar state regulator. So the number one kind of thing as an investment advisor is you have a fiduciary duty to your clients. And as a fiduciary, you have to avoid conflicts of interest with your clients and overreaching or taking unfair advantage of a client's trust. You owe your clients more than just honesty and good faith. A fiduciary must be sensitive to the conscious and unconscious possibility of providing less than disinterested advice. And it may be faulted even when it does not intend to injure a client and even if the client does not suffer a monetary loss. So I gave you a couple of quotes from 2 separate landmark cases when it comes to the fiduciary duty standard for investment advisors. And, you know, you read them and it seems like it's a very high threshold, and it is. It's something to take very seriously, and as I mentioned before, your client doesn't necessarily have to suffer any monetary loss for you to breach your fiduciary duty. So, as a general matter, you have to disclose all material facts regarding any conflict so that your client can make an informed decision whether to enter into or continue an advisory relationship with you or take some action to protect him or herself against a conflict. So, you know, you have to, this is where in Form ADV, you're putting all your conflicts of interest, and this should include any other compensation you receive outside the investment advisory business, any sort of disciplinary actions, you know, if you're on the board of any company. This is all kind of where that information goes in your Form ADV. So you have to make sure you're disclosing all that information, disclose any kind of financial condition of the advisor that may impair their ability to service the clients, you know, disciplinary actions. These are all important. And of course, you can also, at the same time, provide mitigating factors where you're keeping, even though you have these conflicts of interest, that you're still able to provide your client's service at a fiduciary standard. So the second of the requirements is the substantive requirements. And this is where we get into things like advertising and custody. So I mentioned earlier that regardless of whether or not you're registered with the SEC or the state regulator, you are subject to the anti-fraud provisions at the state level and at the federal level. So advisors are prohibited from using any advertisement that contains any untrue statement of material fact or that is otherwise misleading. Specifically, an advertisement cannot use or refer to testimonials, which staff use as including any statement of a client's experience with or endorsement of an advisor. So this is especially important when we're talking about social media and digital marketing. If you have a Facebook page, if you have a website page, if you have LinkedIn, Instagram, fill in the blank, hottest new app, you have to be very careful about the settings you set up where clients, prospectives may be able to leave information about their experience or an endorsement of you as the advisor. You cannot refer to past recommendations made by an advisor unless you set out a list of all the recommendations made during the preceding year. If you're going to be providing graphs, charts, formulas, etc., there's additional disclosures you're going to have to make. And an advertisement cannot refer to any report, analysis, or service as free unless it really is. And believe it or not, this has come up multiple times with several of my clients who will say, you know, schedule a free consultation. And the regulators at the state and the SEC level take the position of, is it really a free consultation? Or is it an enticement to come into your office and sell services? So you have to be very clear if it's truly free, if it's then that there's no strings attached, that nothing comes up in that consultation that would require or request that they sign on to additional services. It truly has to be free. And most times that's not the case. So we generally advise our clients to stay away from using the word free and essentially using synonyms that may not trigger our regulators as much as the word free. Custody. So a registered advisor with custody of client funds or securities is also required to safeguard those client assets. So when do you have custody? If you have possession of client funds or securities, where you're permitted or authorized to withdraw client funds or securities, and then any capacity that gives an advisor legal ownership or access to client funds or securities. So most states require an active investment management or advisory agreement for each client. Some states will even request to review such agreements as a condition of granting state registration. The Investment Advisors Act does not require advisory contracts to be written, but you should have a contract. And the requirement of having an advisory contract also means there's certain provisions that should be included and others that are prohibited from inclusion in your investment management or investment advisory agreement. So advisory fees, you have to state the amount, and advisors and clients are free to mutually agree on what that amount is and the method by which it will be paid. Performance fees are generally prohibited unless there's some significant exception to the rule. Mainly this will be someone who is a qualified client, or depending on whether it's a client and an investor in a fund, there may be some exemptions available there. Advisory contracts must contain a provision prohibiting their assignment without consent of the client. So this is keeping in mind if you are in the middle of a merger or acquisition, what happens to the clients of that other entity, and how do you take over that contract. You cannot do it without the consent of the client. Hedge clauses. So the Act avoids any provision of a contract that purports to waive compliance with any provision of the Act. Now, under hedge clauses comes these release of liability clauses. So the SEC has taken the position that it depends on the content of those limited liability clauses as to whether or not they would be prohibited per the SEC, per the Act. When it comes to termination penalties, the SEC has taken the position that penalizing a client for ending the advisory relationship or causing them to be reluctant to terminate you would be inconsistent with your duty as a fiduciary and could violate the Act. Now, assets under management, so the fees based on the amount of assets under management is specifically accepted from prohibition, so meaning that it's actually allowed by the Act specifically. And that's why we see that it's the most common fee charged. So the next requirement are record-keeping requirements. I did not go through and provide all of the record-keeping requirements. If you're state registered, most state regulators will refer to the actual SEC rule or simply copy and paste the rule and incorporate it into their regulations that way. I've provided here just a few examples of what's considered typical records and then additional records. So typical records being checkbooks, bank statements, written agreements, invoices, all your kind of financial statements. Additional records, personal securities transactions of your employees, a list of all people who are access persons, a memorandum of each order given by the advisor for the purchase or sale of a security, any instruction from a client concerning a purchase or sale. Those would be additional records. But now the requirement to keep records does not turn on the medium in which the document is created or maintained. So whether you keep hard copies or electronic documents, including emails, they have to be maintained to meet the record-keeping requirements. So I actually had a client once, they were subject to a state of Florida routine examination, and they had not been keeping records of canceled checks. And part of the reason they hadn't been keeping records of it is because it was something they specifically had to request from the bank versus them having, gone and logged into their bank account online and downloading the images as those checks came and went out of their accounts. So the CCO, for whatever reason, argued with the regulators and said the bank wouldn't give it to them, it wasn't required, the bank told them they didn't have copies. Anyway, the point being, it's frickin' easy to get copies of canceled checks, and something that's so easy to obtain, even if you don't have it in your face with a regular requesting it, expedite it, call it in, pay the extra fee, whatever you have to do. Even something so simple as copies of canceled checks you have to keep. Even if it's, something as rare as, one check a year, making sure that you're keeping up with those records is incredibly important. Finally, there's administrative oversight. So all records of a registered investment advisor are subject to examination by regulators. At the SEC level, it's the Office of Compliance Inspections and Examinations, or OCIE, and they have various regional offices that then conduct the inspections. All examinations are confidential, and generally speaking, regulators, whether it's at the state or federal level, are going to focus on the activities that are deemed to be high risk. And in fact, for most state regulators, the frequency by which you do receive an examination request, whether it's in person in your office or simply an email document request, is going to depend on the activities you're conducting in your business and whether it's deemed by the regulator to be high risk. So, if you're doing just, portfolio management and financial planning, you're going to be relatively low risk. If you're then sponsoring different funds, you're going to be on the higher risk end of the spectrum, and you can expect to receive more attention from regulators. Similarly, if you've been through an examination and there were some deficiencies that required you to come back and submit updates to whatever documents that were found to be deficient, if you were fined, it's likely that you will be considered higher risk and that you will be receiving additional requests for examination from the regulators, mostly to ensure that you're continuing to make the changes and actually implementing the changes that you represented, that you did. And they want to make sure that you're keeping up rather than regressing back to your old ways. And that brings us to the Chief Compliance Officer. This is the person who's ultimately responsible for administering and maintaining the compliance program. So under Rule 206.4.7, the investment advisory firm is required to adopt and implement written compliance policies and procedures, perform an annual review, and designate a Chief Compliance Officer. The CCO shall hold a position of sufficient authority and seniority, so they possess the power to enforce compliance policies and procedures. Many states impose similar requirements on investment advisors registered in their jurisdictions, the one difference being that some states do not require an annual compliance review. An example of this is the state of Florida. One of the issues that comes up with the Chief Compliance Officer is, again, this power to enforce policies and procedures and to be taken seriously by the firm. So this issue comes up with outsourced Chief Compliance Officers, or even if you have someone in-house who's a Chief Compliance Officer, but only a name, and then doesn't really have the power to make changes or enforce policies. So that's where this Rule 206.4-7 comes into play. So in terms of issues we see, even though the Chief Compliance Officer is responsible, they're not necessarily going to be responsible for everything that goes wrong. So, a person shall not be deemed to have failed to reasonably supervise another person. So if your CCO delegated some tasks to someone else in the firm and that person failed to do what they were supposed to do, the CCO can still get away with not being found personally liable for that person's failures if the advisor has adopted procedures that are designed to prevent and detect violations. The advisor has a system in place for applying the procedures, and the supervising person reasonably discharged those responsibilities and had no reason to believe the supervised person was not complying. So a lot of the case studies we present in our weekly series where a CCO is held responsible because someone else was not fulfilling their responsibilities are generally situations where they knew it was happening, or they didn't have any sort of oversight. So there's a difference between delegating and abdicating. Your CCO cannot abdicate the role. They can delegate, and they still have to have oversight. The majority of enforcement actions that we see is where the CCO has been held personally liable. Are times when the CCO is playing more than one role in the business, such as CCOs are also the owners, the CEOs, the CFOs, the general counsels, the chief investment advisors, the portfolio manager, because oftentimes what we see is that they're spending more time on that other role than they are on the CCO role. And again, they may have abdicated some of the responsibilities to, say, an admin person or a consultant, and they're not providing any sort of oversight. So again, that's where we see a lot of issues. But it doesn't necessarily mean just because you're the CCO that you're going to be held responsible for everything. Also, some other issues that we see where RIAs and their CCOs have been sanctioned are where they're utilizing boilerplate policies and procedures manuals. So you have to make sure your compliance manual addresses the unique risks and conflicts of interest raised by that RIA business. And you can't just say, because I have a 500-page compliance manual, that I am free from liability. It's not about how thick your manual is, how long it is. It's about whether it's specifically designed to prevent violations of securities laws as it pertains to your business. So it's incredibly important that your policies and procedures are customized to your business, and that your staff are actually abiding by and executing on those policies and procedures. So some of the most common mistakes we see under Rule 206-4-7, you have a newly registered firm that creates policies and procedures at the time of their registration, but then fail to either implement it or follow it. Simply having a compliance manual is not enough. The firm needs to do what it says it's going to do and then continue doing it. A second mistake, a newly registered firm creates policies and procedures at the time of the initial registration, but it's generic and not tailored and does not accurately apply to the firm's specific practices and its specific potential risks. So in this scenario, those policies and procedures are insufficient to prevent violations, and if you go through a routine examination, you're likely to face deficiencies or fines as a result. Another mistake, a firm does a sufficient job of updating its Form ADV and other filings, but fails to establish an actual compliance program. So while maintaining and updating Form ADV is critical. It's only one part of implementing and maintaining a robust compliance program. Another mistake we see with new and also with long-established firms is the failure to conduct and document an annual compliance review. So keeping in mind this is required at the SEC level, but not necessarily all states. The annual compliance review requirement is something we often see overlooked, and it's one of the easiest things a regulator can spot and fine you on. So it's the low-hanging fruit. You should not overlook it. It should be conducted thoughtfully and thoroughly and documented. And you do that by performing an annual risk assessment, doing staff training, testing, and other reviews. And remember, document all the work you're doing as part of that annual review. Another mistake, a firm conducts an annual compliance review each year in theory, but has little in practice to show for it. So your policies and procedures are like the Constitution. It's a living, breathing document. So it should be regularly updated to match the business as it continues to grow and evolve, and also to make sure that new regulatory requirements are being properly addressed. I think we can all say that just in the last 10 years, how much our industry has changed, how many new regulations have been imposed, how many new rules have been imposed, and then all of the different information that's come out from the SEC and state regulators as to how advisors should interpret all these different laws and rules. So it's very important to continue to update that manual and document it again. And finally, another common mistake we see is the firm designating a CCO, but that CCO is not qualified, doesn't have the proper training, doesn't really understand what they have to do. So unfortunately, a lot of firms, we actually see them appointing some sort of administrative assistant with no prior experience to take on the compliance responsibilities in the firm. And on top of that, they're not empowered to put in place a robust compliance program or to enforce what's already existing, even if it's not particularly sufficient. And that person may, on top of it, be preoccupied with their existing responsibilities. So if they're an admin, they're an portfolio manager, or have some other role, and that can lead to some very serious issues because, basically compliance isn't being done, and it's very easy to fall behind, and then it becomes the elephant in the room, and you're trying to figure out where to start to start tackling the fact that you haven't been keeping up with those compliance responsibilities. So I'm going to end with a case study. An enforcement action on January 21st, 2015 was brought against a New York RA who had weak policies and procedures that led to numerous compliance issues. The firm's principals had performed the responsibilities, but they possessed little knowledge and had inadequate training. They hired an employee to be a compliance officer, but he too had little experience or training, and in addition, the firm failed to provide any adequate training to employees. Keep in mind that you are required to have your employees review the compliance manual and then actually document they've reviewed it, and to provide ongoing training and education. So although the employees took a yearly computer-based training course, the RA did not provide the initial training or periodic trainings, and what training they did provide was not robust or adequate. So simply having a compliance manual is not enough. The firm needs to do what it says it's going to do. In this scenario, the policies and procedures were insufficient, so leading to all the violations that we've discussed. And, you know, ultimately, it's easy things that you to prevent. You know, it's easy to prevent a fine just by making sure you keep up with these requirements. Now, I get it, it's not a revenue-generating activity. You'd rather spend your time on things that are going to make you money, but this is what's going to keep your business going. It's what's going to continue to provide and give you a business that's going to give you a living, that's going to give your employees a living. So as much as everybody strongly dislikes doing compliance, maintaining a robust compliance culture in their firm, it is absolutely a necessary part to the advisory business and should be taken very, very seriously. So we are at the end of our presentation. Did anyone have any questions? All right. Well, I am going to end the recording.